and thank you for your trust in Injured Workers Law Firm. This video will help you prepare for one of the most important parts of your case, the deposition. While a video can't replace an in-person meeting with one of our attorneys, our experience participating in over thousands of depositions allows us to share a few simple rules that you should keep in mind when preparing for and giving a deposition. Clients who watch this video at least 3 times and read our instruction sheet tend to feel much more comfortable giving a deposition. Remember, there is no way to anticipate every single question that will be asked, but by reviewing your case with you in person and by reviewing deposition mechanics in general, we will help you to be a better deposition witness. Now let's get started preparing you for your deposition. As a reminder, a deposition is sworn testimony given outside of a courtroom. A deposition usually takes place in a conference room with all the attorneys involved in the case present, and sometimes depositions may be video recorded. Most depositions of our clients are held right here in our office, so you will be in a comfortable, familiar setting, which should help keep you at ease. During a deposition, family members and friends are not allowed to be present. No one is allowed to prompt or help you with your answers, including your attorney. And if a person is needed as a witness at the hearing, they are not allowed to hear your deposition testimony. I will rarely, if ever, ask a client any questions during a deposition. I am not going to help the defense attorney gather information against you. However, if I have a real question, I will ask you privately outside of the deposition. On a rare occasion, I may ask a clarifying question during the deposition. I will only ask questions if I feel your case would be hurt if the question went unanswered, but I really don't like doing that. At the end of the deposition, I will tell you, you have the right to read this deposition before a final transcript is created, or you can waive that right. Do you so waive that right? Since you really can't change your answers, or I don't really want you to change your answers, I want you to say, yes, I waive that right. If I'm concerned that some answers may need an explanation, I will ask you that you review the deposition before it is finalized. The deposition will be filed with the commission to be used against you at the hearing. Please understand, if you change your answers, you could be cross-examined on the changes during the hearing. Generally, there are 3 reasons why the insurance company would want to take your deposition. First, they want to meet you. They want to make an assessment of how good a witness you will be at the hearing and how well you will present to the deputy commissioner. Next, they want to know your story. They have only heard the story from their client's side, and they want to know what you have to say about the workers' compensation claim that you've brought. Finally, when you give a deposition, all of the questions and answers are recorded under oath. If you try to change an answer at your hearing, you could be impeached with your deposition testimony. In other words, the insurance company can bring up the fact that you said you had shooting pain down your arm at your deposition, but now you're saying you had dull pain through your arm. This can be used to hurt your credibility at the hearing. Remember, your answers during the deposition need to remain consistent with your medical records, your interrogatory answers, and other recorded materials. If your statements in the deposition are inconsistent, your case will be severely damaged. The insurance company will argue to the deputy commissioner that since you can't get your facts straight, how in the world can the deputy commissioner believe you about how the accident actually occurred? Frankly, we've had to withdraw as counsel from some of our clients' cases and even dismiss cases following depositions when the client just wouldn't listen to anything we said. One last thing, I've never seen a case that was won in a deposition, but I have seen many cases that were lost in a deposition. Remember, giving a deposition is a very difficult task, and it will take all of your strength to complete it successfully. During your deposition is not the time for you to try and convince the insurance company you are right. It is not the time to argue. It is not the time to vent your frustrations. The deposition is the moment for the insurance company's attorney. This is when he tries to put words in your mouth to be used against you later. This is their time to see what you will say at the hearing and if they can find a loophole. This is their time to try to win the case and look good for their client, the insurance company. The hearing is when we get to tell our story and convince the deputy commissioner. The hearing is where we will hopefully seek and find justice. Since most defense attorneys take depositions weekly, they tend to have typical questions that they ask each time. You should be prepared to answer questions about who you live with and who your dependents are, what medications you're on, your prior work history, your education level, the work accident, and medical treatment related to the work accident. Each case and defense attorney is unique, so I'm giving you a general outline to help you feel comfortable when the questions are asked during the deposition. We don't want you giving a prepared statement when a question is asked. Along the same lines, you need to know that they will ask you questions about what you do during the day. They will ask this because they may have a private investigator watching you and want to know if your actions are consistent with your deposition testimony. They ask you about job searches because this is the easiest way to deny people's workers' comp benefits. They will ask about doctor's appointments to test if you said the same thing to the doctor as you say at the deposition. They may act ignorant about the facts of your case, hoping you will intentionally leave something out which could be harmful to your case. However, these are insurance company defense lawyers. They know what they're doing and they are good at what they do. I can tell you without a doubt that they have done a criminal background check on you. They have a report from the National Insurance Database. They have memorized your medical records. They have called and followed up with potential employers. They've looked at all your social media sites. They've talked to your employer and coworkers about whether they think you are truthful and have researched what you are like in general. Know that the defense lawyers are going to do their best to win and have your claim denied. I want to now tell you about the rules we use as part of a deposition. The first rule and most basic rule of all is to tell the truth. The lawyers and the insurance companies paying them are very experienced investigators. You simply cannot get away with not telling the truth. In workers' comp cases, it is most important when talking about past injuries, accidents, and medical care. Insurance companies have huge databases which keep track of all of this stuff, and they like to share information. We cannot learn about a prior accident for the first time in the middle of a deposition. This is simply the kiss of death in your case. The second rule is that a deposition is not a friendly conversation. As nice as some of the defense lawyers may be, they are not your friends. You are on stage during the entire time you are in their presence. You are here to answer their questions, not to have a friendly chat. The insurance company's attorney wants you to open up and give them all sorts of information. They are hoping to uncover something that will help them at the hearing. During the deposition, it's best to answer questions with a yes or a no, without any additional explanation. If an explanation is requested, a 1 or 2 sentence explanation is best. Remember, when you give your deposition, listen to the question asked. If you do not understand the question, then you cannot answer the question. If you feel that the question is confusing, ask the lawyer to rephrase the question. As your lawyer, if I feel a question is confusing, I will object and ask the lawyer to rephrase the question. Do not ask for every single question during the deposition to be rephrased. You will come off as being evasive if that happens. Here's a precaution to watch out for. In normal, everyday conversation, we anticipate the question once someone begins asking it. This is a bad habit, but it happens to all of us. You need to resist the temptation to do that during your deposition. By starting to answer a question before it's completely asked, you may be answering a different question and giving the other lawyer a clue as to where to go next. It's much better to simply relax, take a deep breath, and let that lawyer finish the entire question. Once you start to give your answer, the rule is to just answer the question and stop talking. Again, it's natural to try and tell your whole story. That's what we do in everyday life, but that's not the way a deposition works. When you try and tell your whole story, you are actually helping the defense attorney win, which means you lose. You see, it's the other lawyer's job to get all the information you have. If they don't ask the right questions, we don't give them the answers. Let me share a story with you. I once took the deposition of a doctor. It was the hardest deposition that I ever took because all he did was answer the question that I asked. I don't think his heart rate went up at all during the deposition, and I found it to be a very frustrating experience for me because he would not give me anything without me pulling it out little piece by little piece. That's the way we want you to be at your deposition. And don't worry about looking unfriendly or unenthusiastic. If they don't ask the right questions, you don't give them the answer. Here's a little trick that is sometimes used. A lawyer asks a question and you answer. Then he just sits there. He is hoping you will fill the silence with more information, but just don't do it. Don't give the lawyer any information that they have not asked for. Remember, it's not your job to figure out where the lawyer is going with a set of questions. The lawyer has a plan and is going to get there no matter what. The problem is, if you try to anticipate what the second or third question down the line is, you may end up messing up your answer to the current question. I once had a client who began the answer to every question with, well, what you are really asking and what you really want to know is such and such. She was one of the ones who broke all the rules, and I had to withdraw as her attorney on her claim shortly afterwards. It is not your job to tell the lawyer what they really want to know and what they really want to ask. That's their job. Your job is to use as few words as possible to answer just the question that they ask. Do not volunteer information. If the lawyer asks, when did you first go to the doctor? You tell him the date range. You don't tell him that the doctor diagnosed you with a muscle strain, that the doctor only did an x-ray, or that the doctor took you out of work for a month and he prescribed you pain medication, etc. Those are all examples of volunteered information which seem very obvious, and nearly every client tells us, oh, don't worry about this. It won't happen to me, but it probably will. The more times you watch this video, you are training your brain to kick in, reminding you that, oh, they told me not to volunteer any information. Volunteering the answer to questions they didn't ask just gives them good ideas for more questions, some of which may ultimately expose any soft spots you may have in your case. Clients often ask, what if I really don't know the answer? No problem. Answering I don't know is an appropriate and maybe the best answer for some of the questions. You don't get any extra points for having something to say about every single question you are asked. And for heaven's sakes, neither we nor the lawyers on the other side want you to guess at any answer. It's okay if you don't remember exactly. Tell the lawyer that you are approximating an answer, such as a distance or a recollection as to a date, but please don't say something with certainty that you really aren't certain about. Remember, your entire testimony is going to be recorded, typed, and used against you later. It will be submitted to the deputy commissioner at the hearing for him to read. If you don't know the answer, just say that you don't know the answer. Also, remember that there is a difference between not knowing an answer and not remembering an answer. There may be some fact that you once knew but cannot recollect at the time you are giving your deposition. It's okay to say, I don't remember now. But if you do that and you remember 6 or 8 months from now at the hearing, they're going to ask you how your memory got better. So here's the rule. If you answer at your deposition that you don't remember something, but later you do remember it, make sure you tell us. We can then tell the other side so they cannot surprise you at the hearing with a question like, oh, well, today you remember that there was oil on the floor, but 8 months ago when I took your deposition, you couldn't remember if anything was on the floor. Were you lying then or are you lying now? I want to talk for a moment about some natural human tendencies which can be harmful in a deposition. Most people are naturally not accurate when it comes to dates, times, and distances. If a question was, after you fell, how long were you on the ground? The true answer is, I do not know. But many people want to put a time on it. However, unless you looked at your watch the second you fell and looked at your watch again the second you stood up, you do not know how long you were on the floor. Any exact time that you give is only a guess. I want no guesses in your deposition without you expressly saying, I'm guessing it was, and then sharing your answer. This works for any questions that are seeking information about time, dates, and distances. You can use your best recollection as long as your answer begins with, "I'm guessing it was." Unless an event happened on Christmas, your birthday, or some other memorable date, it's easy to forget an actual date. When giving your answers, never use adjectives such as absolutely or without a doubt. This is especially true of doctor visits. If asked, when was the last time you saw the doctor? Unless it was yesterday, the best answer would be, "I'm guessing it was about 4 or 5 weeks ago." You could also ask to see the medical record and basically state, "If the doctor notes state that I was at his office on a particular day, then I believe that is the actual date." It is very common for defense attorneys to try to trap claimants into giving specifics like time and dates when they have actual documents of another date or another time frame. Giving the wrong date, time, or distance would be considered inconsistent and would hurt your credibility and believability. I heard one deputy commissioner label a claimant as being an inaccurate historian, so he could not be believed on the bigger issues. Before your deposition, you will have a copy of your medical summary, the recorded statement that you gave the insurance adjuster, if you gave one, and your answers to interrogatories, plus the insurance company's answers to their interrogatories. You will need to review these so that you can be specific and recall exactly what you have originally stated as the events of the accident. You need to be consistent with all of your statements. During the deposition, you should be polite and professional, but don't be chummy. Most likely, the defense lawyer will have good manners and say things to put you at ease. There are very few lawyers who act overly aggressive like some of the lawyers you may see on TV. Remember, the defense lawyer has their job to do and you have yours to do. Their job is to ask questions. Yours is to answer those questions truthfully and to the best of your ability. The more chummy and friendlier you get with the lawyer, especially before the deposition even begins or at breaks, the more likely it is to let your human side take over and you will start to babble out answers and information you will regret later. Let me be chummy with the attorney. That way I can get confidential information out of them later, but I would like you to be as silent as possible. You want to look your best for the deposition. We like to tell people to dress as if they were going to court or to church or another place of worship. Please don't wear shorts or jeans or sweatpants or t-shirts. Try to limit your use of slang when you speak and don't chew gum. If you have a technical background, such as legal, scientific, or medical background, please still try to use plain words. Even though we are lawyers, we try our very best to use plain English. You really aren't going to impress anyone by using words you think the other lawyer doesn't know. Most lawyers are very, very experienced and have deposed everyone in any medical, professional, or other specialty that you could imagine. Basically, they've heard it all and they're not going to be impressed by your use of big words. Let me talk for a few minutes about your demeanor and, frankly, our rule in the deposition. First, we understand that in many, if not all of our cases, what you're being deposed about is something very personal to you. You may feel that, at times, the other lawyer is prying or asking inappropriate questions. Remember, we are very experienced in taking and defending depositions and having a good grasp on what questions are legally appropriate or legally inappropriate. To some extent, you're going to have to really trust us on this one because we know what a deputy commissioner would allow and not allow. By all means, if you feel that your privacy is truly being invaded, let us know discreetly during the deposition and we can leave the room and discuss it. Remember, when you are bringing a lawsuit alleging that you've been injured and suffered an injury, your life, unfortunately, does become an open book, and most questions about your past medical history, mental health history, counseling, work history, marital status, etc. are all valid questions for discovery. This doesn't mean that those issues will necessarily come up at the hearing, but virtually all deputy commissioners are going to let the other side pry a bit into your past medical, social, work, and mental history. Please try not to let the other lawyer get you upset. Frankly, if you do get upset, you lose. Once your emotions are engaged and you get mad or scared or defensive, you are not in control of what you are saying. The lawyer will stay in control. keep her emotions in check, and frankly start to get you to say things that she'll love and you'll hate later. Remember too, that the other lawyer is just doing his job. He's not the enemy, but he does represent the enemy insurance company. He'll ask a lot of questions that may make you think that he has never read one page of the file, very rudimentary and general questions. And then he'll probably ask you a lot of questions that will make you think, gee, do I really have to answer that question? Again, trust us, the answer is yes. For most questions, you do have to answer. In our private meeting with you, prior to your deposition, we will try to have anticipated all the questions that you are likely to be asked, or at least all of the subject matters that you are likely to be asked about. There are only very, very few instances where the witness has a legal right to not answer the question asked. If those questions come out, we will object and instruct you not to answer. If we do instruct you to not answer the question, please honor that instruction. Be careful about talking about anything other than the weather during any breaks we take in the deposition. This is especially important when you are giving a deposition in another lawyer's office. We just never know what ears are around to listen to our conversation, period. Let's talk for a minute about objections. Our job at the deposition is to make sure that the questions are understandable and that they are legally proper. If your lawyer begins to make an objection, he or she will say objection, and at that point you need to stop talking and be quiet. Listen carefully to the objection we make, and then if we say you may answer the question, then you may go ahead and answer that question. What we have done from a legal perspective at that point is to preserve the objection to be able to take that issue up with the deputy commissioner later on if need be. If after we make an objection, you need to have the question asked again, just say so. So how do you prepare for your deposition? First, I know it's easy for us to say, but I don't want you worrying too much about your deposition. Just prior to the deposition, I ask that clients arrive about 45 minutes early. At this time, you'll be given a copy of a medical summary that we've created, the insurance company's answers to interrogatories, your answers to interrogatories, a copy of your recorded statement if you gave one to the company, and possibly some other specific documents. I want you to read all of these documents. This is done so that you can try to be as consistent with your prior statements. It is not done for you to memorize dates, contest that the recorded statement is not accurate, etc. But other than that, I would not do a lot of studying to prepare for the deposition. A deposition is not a memory contest. You don't need to know the exact date of every medical bill incurred, every date you saw the doctor. Your time is better spent getting rest, keeping your head clear, and frankly, doing other things that would take your mind off of the deposition. The one thing we really need to know in preparing you for your deposition is what questions that you are afraid of. We will ask you if there's anything out there that you are worried about being questioned about, or that you haven't discussed with us but may possibly come up. Look, there are a lot of things we can do to solve problems if we know about them, but we can't solve any problems or anticipate any problems if we don't know all the facts about your case and your life. Please don't let us be the last to learn about something significant that is going on in your case, because you were perhaps too afraid or embarrassed to talk to us about it. We need to know this prior to the deposition and not during it. Okay, we're almost done. Really, what I want to get back to is tell the truth at the deposition. Listen carefully to the question. Is the lawyer asking two questions in one? Is every fact that the lawyer phrases in his question a true fact? If it's not, tell him. If he's asking two questions in one, even if it just seems that he is, break your answer down into two answers. If he begins a question with a generalization such as, now, let me understand what you just said, and begins to paraphrase back your answers, make sure what he is telling you is indeed an accurate paraphrase or recollection of your answer. Okay, we know that you'll do just fine at your deposition. We will be there with you, and once the deposition is completed, we'll have a written transcript back in a couple of weeks. Sometimes, since I take extensive notes during the deposition, I do not order a copy of it due to the fact that it would cost my clients anywhere between $300 and $500, and I might not think that it's worth getting a copy of it. What we'd really like you to do now is to carefully go over the information sheet that we've given you and listen to this recording about 3 more times prior to your deposition in preparation. Thank you for watching.